SchnitzelNinja.
Case number 2, CA-CV-0315 FC. In the Court of Appeals of the State of Arizona, Division 2. Laura Owens, Petitioner, Appellant, versus Clayton Echard, Respondent, Appellee. Maricopa County Superior Court Case number FC 2023-052114. Appellee's Answering Brief. Case number 2, CA-CV-2024-0315 FC. In the Court of Appeals of the State of Arizona, Division 2. Laura Owens, Petitioner, Appellant, versus Clayton Echard, Respondent, Appellee. Maricopa County Superior Court Case number FC 2023-052114. Appellee's Answering Brief. Statement of the case. This somewhat unusual case comes before the Court of Appeals following paternity litigation without a proven pregnancy, or even credible evidence of intercourse that could have produced one. Although the opening brief makes sweeping claims of jurisdictional deficiency and judicial misconduct, the core issue is whether a person may 1. File a petition alleging paternity, 2. Fail to provide objectively sufficient proof of pregnancy, 3. Tamper with evidence and lie under oath, and 4. Opt out of litigation consequence-free. The trial court determined that Laura Owens could not do those things without making Clayton Echard whole for the fees he incurred to defend himself. The appeal followed. Statement of facts and procedural history. Because this court generally defers the findings of fact of the trial court and most of the factual findings are not challenged, Clayton will provide a non-comprehensive summary of the facts and history. Footnote 1. Laura filed various motions at the beginning of the action that were dismissed by the court: motion to communicate, expedited motion to seal, etc. For the sake of consciousness, these filings are not part of the summary but are present in the under advisement ruling, issued June 17, 2024. Additionally, although there were 2 companion actions, an order of protection and an injunction against harassment, that occurred during the underlying paternity action, footnote 2, namely a protective order action brought by Laura against Clayton, which was heard before Judge Duty, FC 2023-052771, and an injunction against harassment brought by Clayton against Laura, which was heard in 2 settings before Judge Galketsis, CV 2023-053952. Both actions were made part of the record for the paternity action by the trial judge. They are only discussed to the extent relevant to the judgment in this case. On May 20th, 2023, Laura performed oral sex on Clayton. Footnote 3. Laura alleged there was non-consensual sexual intercourse, but this was not alleged initially in the court filings. It was not alleged until 2024. On August 1st, 2023, Laura filed a petition to establish paternity, legal decision-making, parenting time, and child support, alleging she was pregnant with Clayton's twins after the May 20th sexual encounter. The trial court found the sexual conduct did not result in pregnancy. HCG tests. Laura has a medical history of diagnosed conditions that affect the likelihood of pregnancy, including epilepsy, polycystic ovarian syndrome, and ovarian cancer. Laura, quote, has PCOS since the age of 17 and does not have a regular menstrual cycle, end quote. On May 31st, 2023, Laura allegedly took an at-home pregnancy test, which apparently showed the presence of human chorionic gonadotropin in her urine, HCG. This was the 4th time she had tested positive for pregnancy in her lifetime. All prior alleged fathers, quote, believed she fabricated the pregnancy and doctored medical records, end quote. On June 1st and June 19th, 2023, additional urine tests showed the presence of HCG, one at Banner Urgent Care and another completed at Clayton's home. On its own, the presence of HCG is not determinative of pregnancy, which requires confirmation from a medical provider through an ultrasound or other verifiable objective evidence. For example, giving birth. Alternative reasons for the presence of HCG in blood and urine include epilepsy medications, anxiety medications, clozapine, horse urine, fertility treatments, for example, IVF trigger shots, and cancer. On October 16, 2023, Laura allegedly obtained a blood draw which indicated her HCG levels were 102. Laura, quote, changed the results to reflect levels of 102,000, end quote. Both medical experts, Dr. Deans and Dr. Medhill, confirmed that an HCG level of 102 indicates a non-viable pregnancy. Even with this information, on October 18, 2023, Laura requested pre-decree mediation, claiming that Clayton, quote, acts as if the unborn children don't exist despite a preponderance of the evidence, end quote. Additionally, on October 24th and November 2nd, 2024, Laura testified before Judge Galketsis that she had a, quote, high-risk pregnancy, was, quote, 100% 24 weeks pregnant, and was due on, quote, February 14th, 2024, and was being actively seen by Dr. McCool and Dr. Higley, who she saw, quote, last Friday. On October 25, 2023, Laura testified before Judge Duty regarding the, quote, validity of the sonogram sent to, end quote, Clayton, that she, quote, believed she was having fraternal twins, one boy and one girl, end quote. Footnote 4. By agreement of both parties, the trial took notice of the proceedings in FC 2023-052771, Laura's order of protection against Clayton, and CV 2023-053952, Clayton's injunction against harassment against Laura, and reviewed the FTR recordings of the evidentiary hearings. Sonograms, miscarriages, and medical providers. On March 1, 2024, Laura testified that she obtained a sonogram at Planned Parenthood that confirmed the presence of twins in July of 2023, and that she modified the image to falsely attribute it to Southwest Medical Imaging, SMILE, by altering the heading, name, and date of the sonogram. Laura alleged she obtained the original sonogram anonymously at Planned Parenthood, Mission Viejo on July 7, 2023. Planned Parenthood does not accept patients using an alias. Patients are required to provide a government-issued form of identification. On April 15, 2024, Laura claimed the original sonogram was from a visit to Planned Parenthood Costa Mesa on July 2, 2023. On March 18th and April 17th, 2024, Clayton sent HIPAA record requests to Planned Parenthood in Orange and San Bernardino counties, which denied having any sonogram records for Laura, and noted the alleged sonogram was not, quote, consistent with ultrasound images generated by, end quote, their practice. Then, for the first time at trial on June 10, 2024, Laura testified that the sonogram was from a visit to Planned Parenthood Los Angeles on July 2, 2023. Laura claimed this was the reason Clayton was unable to obtain any records from the Planned Parenthood visits she previously disclosed. They were false statements. On February 21, 2024, during a status conference, Laura stated she has, quote, miscarried sometime in September or October 2023, end quote. On March 1, 2024, Laura alleged she passed, quote, two sacs which appeared to have a membrane, end quote, in September or October of 2023. Laura later claimed she passed the tissue on July 23, 2023. Laura alleges she did not experience heavy bleeding and spoke with an online telehealth provider who found it, quote, hard to tell whether Laura had a miscarriage and advised her to seek in-person care, which she did not do. Laura alleges she took additional HCG tests on July 25, 2023 and August 1, 2023, which were positive. Laura made 4 appointments with Dr. McCool, a maternal fetal medicine specialist, in the month of August 2023. Laura rescheduled 3 of the appointments and canceled the 4th. In the injunction action before Judge Galketsis on October 24, 2023 and November 2, 2023, Laura testified she actively had a, quote, high-risk pregnancy, was, quote, 24 weeks pregnant and due on, quote, February 14, 2024, and was being seen by Dr. McCool and Dr. Higley, who she saw, quote, last Friday. On October 24, 2023, October 25, 2023, and November 2, 2023, Laura was seen standing and rubbing what appeared to be a swollen abdomen in the OOP and IAH hearings. Laura's records show she was never treated by Dr. McCool, Dr. Higley, or any other in-person obstetrician or gynecologist. On November 14, 2023, Laura took 2 pregnancy tests at MomDoc, which confirmed she was not pregnant, disclosed to Clayton on February 23, 2024. Paternity testing, boy and girl twins, and procedural history. On August 1, 2023, Laura filed her petition to establish, alleging she was pregnant with twins. On August 21, 2023, Clayton filed a pro per answer, denying that Laura was pregnant with his children, denying intercourse, denying paternity, and requesting an award of attorney's fees pursuant to ARS 25-809G and ARS 12-349. Clayton moved to amend his response on December 12, 2023, and filed the amended response on January 26, 2024. On October 2, 2023, Clayton and Laura participated in a paternity testing with RavGen. On October 6, 2023, the results indicated, quote, little to no fetal DNA, end quote. On October 18, 2023, after Laura learned she had no viable pregnancy via blood test on October 16, 2023, Laura requested pre-decree mediation, claiming that Clayton, quote, acts as if the unborn children don't exist despite a preponderance of the evidence, end quote. Recall that on November 2, 2023, Laura testified to being, quote, 24 weeks pregnant, end quote, with twins, and due on February 14, 2024. For example, weeks after she already knew she was not pregnant, according to her narrative. On December 6, 2023, the results of another RavGen paternity test indicated, quote, little to no fetal DNA, end quote. The results for a third test were lost in transit. On December 12, 2023, Clayton filed a notice of filing affidavit of non-paternity. On December 28, 2023, Laura filed a motion to dismiss petition to establish paternity, legal decision-making, parenting time, and child support with prejudice. Motion to dismiss, alleging she was, quote, not now pregnant with respondent's children, end quote. The court denied the motion to dismiss on February 14, 2024, because the issues of attorney's fees, costs, and sanctions remained. On January 2, 2024, Laura filed an expedited motion to quash deposition, which the court denied after briefing. On January 3, 2024, Clayton filed a response objection to Laura's motion to dismiss and a motion for sanctions pursuant to Rule 26. Laura did not appear for her first scheduled deposition. On January 17, 2024, Laura filed a motion for confidentiality and preliminary protective order referencing a miscarriage for the first time. On February 2, 2024, Laura deposed Clayton. During the status conference on February 21, 2024, Laura claimed she miscarried in, quote, September or October, end quote, and with consent of the parties, the court advised it would review the IAH and OOP hearings, treat the motion to dismiss as a request for attorney's fees equally, and hear evidence and testimony as it applies to sanctions and attorney's fees and costs dating back to the filing of the petition, all pleadings filed within the Maricopa County Superior Court. On February 27, 2024, a few days before her rescheduled deposition, Laura sent a letter to Clayton indicating she would sue him for approximately $1.4 million unless he agreed to unconditionally dismiss the paternity action. Clayton deposed Laura on March 1, 2024. For the first time, Laura stated she passed, quote, 2 sacs, which appeared to have a membrane, end quote, in, quote, September or October, end quote, of 2023, and took a picture of them. Laura later claimed she passed the tissue on July 23, 2023. On March 11, 2024, Clayton filed a motion to compel Laura to disclose the alleged Planned Parenthood records, the image of the 2 sacs, the name of the telehealth provider she spoke to on the day of the alleged miscarriage, and a file from a 2014 paternity case, granted 4/9 2024. On March 25, 2024, Clayton filed a motion for joint hearing, granted 4/25/24, and an amended motion for relief from judgment based on fraud, requesting the court take additional evidence against the OOP Laura filed against him on October 6, 2023. The latter motion was granted on May 21, 2024, with the court reiterating it would view the records from both the IAH OOP hearings to, quote, rule on the validity of the OOP and any award of attorney's fees at trial, end quote. On April 3, 2024, Clayton withdrew his prior motion for Rule 26 sanction. On April 4, 2024, Laura filed a notice of non-objection. The court accepted the withdrawal on April 4, 2024, but did not distribute the order until May 16 due to a clerical error. On April 8, 2024, Laura filed a motion to compel lunch and for alternative relief, denied April 30, 2024. On April 12, 2024, Laura moved the court to take judicial notice of Laura's prior lawsuit against another person, GG, whom she also alleged impregnated her, granted 4/26/24. On April 30th, 2024, Laura filed a motion in limine seeking to preclude the testimony of 3 other men whom Laura alleged impregnated her in the past. Motion denied. On May 10th, 2024, Laura filed a motion for judgment on the pleadings and renewed motion to dismiss, which the court deemed moot and therefore denied on May 28th, 2024. On June 3, 2024, Laura's prior counsel filed an Ethical Rule 3.3 Notice of Candor, indicating that their statement at the status conference that, quote, Ms. Owens has not lied in this case, end quote, was no longer true, considering Ms. Owens' deposition on March 1, 2024. Trial, final judgment, and post-trial filings. From May to June 2024, the parties filed various other motions, requests, and statements in preparation for trial. The court held an evidentiary hearing on June 10, 2024, and issued its final judgment in the form of an under advisement ruling, the UAR, on June 18, 2024. The UAR summarizes the history, the court's findings, the legal analysis of various issues presented, and the relief awarded with substantial detail. As to paternity, the court found it could not establish Laura was pregnant as a threshold matter, then further elaborated that Laura failed to meet the burden of proving Clayton was the father of the alleged pregnancy. The court granted Clayton's request for a finding of non-paternity. The court also awarded Clayton attorney fees and costs based upon ARS 25-324B and 25-415, with a 2-page explanation of the findings supporting the award. The court found Laura initiated the litigation without basis or merit, that her petition was, quote, premature at best and fraudulent at worst, and that Laura's explanation for requesting mediation after she already knew there was no viable pregnancy was disingenuous, misleading to the court, and perjurious. The court also found Laura repetitively failed to comply with Rule 49 by 1. Altering HCG test results, an ultrasound and a sonogram, and 2. Falsely reporting facts about her alleged Planned Parenthood visits, including a brand new disclosure at trial that she sought care at Planned Parenthood in Los Angeles, despite prior assertions and discovery being directed to other Planned Parenthood locations and entities. The court found Laura filed her petition in bad faith, that it was not grounded in fact or based on law, and that it was for an improper purpose. The court found Laura provided false testimony in all 3 cases against Clayton and unreasonably threatened to sue him for $1.4 million in collateral allegations unless he agreed to dismiss the action Laura initiated. Lastly, the court found Laura knowingly presented a false claim and knowingly violated a court order compelling disclosure or discovery. Footnote 5. To be clear, Laura does not challenge these findings on appeal. Instead, she asserts the court should have dismissed the case before she engaged in most of these behaviors, so they can simply be ignored. After the ruling on July 8, 2024, Laura filed a notice of change of judge for cause, memorandum, and affidavit in support, alleging the trial judge conducted an independent investigation into the facts via social media. After briefing, presiding family court judge Honorable Rhonda Fisk denied the notice, finding Laura did not present a prima facie case for bias or prejudice and, if such error occurred, it was harmless given the overall weight of evidence supporting the judgment. The same day, Clayton filed his application for attorney's fees and costs, which was granted on August 16, 2024, after a timely response and reply. On July 12, 2024, Laura filed a motion to vacate judgment, motion for new trial, alternatively, motion to alter amend judgment, motion for leave to exceed page limits, which the court denied on September 9, 2024. On September 5, 2024, Laura appealed from the order reapplication for attorney's fees and costs seeking review of, quote, all prior non-appealable interlocutory decisions, orders, and rulings, end quote, made by the trial court, and she filed an amended notice to include the trial court's denial of Laura's motion to alter amend. Laura cites ARS 12-2101A1, appeal from final judgment, A3, appeal from an order affecting a substantial right that prevents final judgment from being entered, and A5A, order refusing a new trial for appellate jurisdiction. Statement of the issues. Laura's opening brief argues 5 issues. Further references to the issues presented in the opening brief will be to the issue numbers. Jurisdiction. This court has an independent duty to determine whether it has jurisdiction to consider the issues raised in an appeal. State versus Lemon. The appellate court's jurisdiction is purely by statute. Arizona Constitution 6-9. Intermediate appellate jurisdiction is only as provided by law. ARS 12-2101. Listing instances in which an appeal may be taken to the Court of Appeals from Superior Court. The opening brief cites ARS 12-2101A1, appeal from final judgment, A3, appeal from an order affecting a substantial right that prevents final judgment, and A5A, order refusing a new trial. Most of the issues Laura presents for review do not arise from the final judgment. Issues 1, 3, 4, and 5 all arise from her argument that the trial court should have granted one of Laura's pretrial motions to dismiss. Denial of a motion to dismiss cannot be directly appealed, but it can be reviewed on appeal from a final judgment only if it is an intermediate order involving the merits of the action and necessarily affecting the judgment. ARS 12-2101A, State v. Meza. Argument. The opening brief does not prove error or establish grounds for reversal. The court awarded Clayton attorney fees as a statutory remedy, not a Rule 26 sanction, making most of Laura's arguments categorically inapposite. There is no safe harbor provision to avail a party whose conduct falls short of their duties under ARFLP 49, who knowingly presents a false claim or violates a court order compelling disclosure or discovery under ARS 25-415, or acts unreasonably under ARS 25-324 and 25-809G. The opening brief freely admits that Rule 26 safe harbor applies only to the conduct that allegedly violated that rule. Quote, for that reason, Rule 26's safe harbor must be construed as not only shielding litigants from punishment under Rule 26, but also from punishment under any authority, to the extent the punishment is based on the same conduct that allegedly violated Rule 26, end quote. Issues 1, 3, 4, and 5 all rest on the same mistaken assignment of error, and they all must fail for the same reason. The court did not err by denying Laura's motions to dismiss and acted within its authority to award Clayton attorney fees under Title 25 statutes. Moreover, Laura has not proven reversible error in the form of misconduct by the trial judge as alleged under Issue 2. Clayton contests the sufficiency of the evidence Laura presented to establish such error occurred. Even if those facts are accepted as both true and sufficient, the standard in Title 25 cases is harmless error, not structural error. An erroneous finding regarding a collateral fact used only for impeachment is harmless given the overall weight of the evidence in this case. For these reasons, the court should affirm. 1. Issue 1. The court did not sanction Laura under Rule 26 and did not err by awarding Clayton attorney fees under other authorities. A. Standard of review. Generally, an award of sanctions is reviewed for abuse of discretion. B. The court did not sanction Laura under Rule 26. The first threshold of this argument is whether the trial court sanctioned Laura under Rule 26 at all. To even consider Laura's argument, which she repeatedly asserts disposes of the entire case on appeal, this court must first entertain a most meaningless hypothetical. What if the trial court sanctioned Laura under Rule 26 and no other authority? Although Clayton moved for Rule 26 sanctions based on Laura's court filings relatively early in the case, he withdrew that motion on April 3rd with no objection by Laura and proceeded with other claims for relief under ARS 25-324, 25-415, and 25-809G. By the time of trial in June, there had not been a pending Rule 26 motion for over 2 months. After Clayton withdrew the motion, Laura argued, in multiple filings and at trial, that the court could not award sanctions under Rule 26. Laura filed her first motion to dismiss after Clayton answered the suit, but before the motion for Rule 26 sanctions. By the time of her second motion to dismiss, Clayton had already withdrawn the motion a month earlier, largely to avoid unnecessary satellite litigation Laura threatened to bring over the safe harbor issue. She raised her arguments over Rule 26 again in her pre-trial statement and at trial. The court included detailed findings about the Rule 26 issue in the UAR, but the court ultimately only awarded attorney fees and costs under Title 25 statutes based on relative financial positions, unreasonable positions, and discovery and disclosure violations. The trial court did not rely on Rule 26 at all, despite Laura making it the centerpiece of her position in the proceedings. Therefore, to the extent Laura argues Rule 26 controls the outcome, the issue is simply moot. The parties can debate various sub-issues, for example, whether ARFLP 26, ARCP 11, and FRCP 11 have identical requirements, are governed by the same law, whether Clayton complied with Rule 26, whether Rule 26 requires strict compliance, whether non-compliance precludes an award sua sponte, whether a remedial award of attorney fees and costs even qualifies as a sanction, and so on. But the inconvenient truth is that none of these questions are actually before this court. Laura's reliance on her interpretation of Rule 26 is misplaced. Laura, like every other Title 25 litigant, knew she may be ordered to pay Clayton's attorney fees when she filed the petition, received notice again when he requested fees in his response under ARS 25-809G, and was reminded in nearly every subsequent filing and hearing thereafter. Even if Clayton never mentioned Rule 26 whatsoever, statutory remedies were always available. Laura asks this court to award her carte blanche because of a Rule 26 motion having once been filed. Her reading of Rule 26 would turn the safe harbor into a formalistic sinkhole and do damage to the statutory attorney fee scheme that has nothing to do with signing of filings. C. Rule 26 does not apply to awards given under ARS 25-324, 25-415, or 25-809. Laura argues that failure to strictly comply with Rule 26 precludes sanctions under any other authority. On its face, nothing like Rule 26 references any of the statutes permitting the court to award attorney fees and costs in Title 25. For example, ARS 25-324A, award of attorney fees after considering financial positions and reasonableness. ARS 25-415, award for false claims or disclosure discovery violation. ARS 25-809G, functionally identical to 25-324 in paternity proceedings not involving legal decision-making, parenting, time, child support statutes. Laura relies mostly on a case law interpreting the federal civil rules for the idea that sanctions are not available without invoking Rule 26, but this reading would expand the rule's scope far beyond its language, purpose, and common sense interpretation. To be clear, Rule 26 and its civil corollary ARCP 11 applies only to the signing of documents filed with the court. See ARFLP 26A1. By signing a document and filing it with the court, the signer certifies that they have conducted a reasonable inquiry and believe the filing is for a proper purpose, warranted by law, and supported by facts. ARFLP 26B 1 through 4. If the document is signed in violation of those requirements, the court may impose sanctions. ARFLP 26C1. The remainder of the rule describes the procedure for requesting sanctions under this rule. ARFLP 26C 2 through 3. Quote, before filing a motion for sanctions under this rule, the moving party must ... End quote. Rule 26 says nothing about the myriad factors courts consider in whether to award fees in family law actions, including financial resources for the parties, reasonableness of positions, discovery and disclosure misconduct, or any other substantive basis for fees awards outside the signing of a document. Laura's argument seems to assume that Rule 26 is the exclusive vehicle to request an award of attorney fees and costs, but there is no authority supporting this interminably broad limitation of the family court's remedial authority. The court's authority to award fees in other civil actions is far narrower, mostly relying on ARS 12-349, except in certain actions with specific fee statutes, for example, contract disputes. Of relevance here, ARCP 11's safe harbor provision is also codified in statute. See ARS 12-349C. Attorney fees shall not be assessed if offending party voluntarily dismisses within a reasonable time after learning a claim is unjustified. There is no counterpart to this provision in Title 25. The court must also consider the practical implications of Laura's argument. See Husterlid v. Steakbake, 253 Arizona, 569, 574, 12. When language is ambiguous, consider effects and consequences of differing interpretations. Laura's argument declares that Rule 26, once invoked, affords a party an absolute right to withdraw from litigation with no consequences. It must logically follow, then, that the safe harbor opportunity only comes into existence if a party or the court notifies the offender of their intent to seek Rule 26 sanctions. Arguing sua sponte sanctions cannot be imposed without a show cause order triggering safe harbor. She further asserts that other laws allowing sanctions no longer apply after a party claims a specific act violated Rule 26. For example, the act of invoking Rule 26 or alleging a Rule 26 violation makes the rule the exclusive remedy for that conduct. Assuming arguendo that these assertions are true as to sanctions under Rule 26, Laura asks this court to craft a safe harbor as to all forms of attorney fees awards notwithstanding their basis in law. Even the federal courts relying squarely on FRCP 11 do not go this far. See Carancini v. Nationstar Mortgage, LLC, 97 F. 4th, 1099, 1103, 8th Circuit, 2024. Even if safe harbor is not given, court could still have imposed sanctions under Rule 11, C3, statute, or inherent powers. Matsumaru v. Sato, 521, 1013, 1016, D. Arizona 2007. Plaintiff will have opportunity to persuade the court that sanctions should not be imposed under the other authorities. This argument, if accepted, would assign a talismanic quality to Rule 26. Under Laura's interpretation, the offending filer would have an unconditional right to opt out of the litigation, no matter how egregious their conduct or unreasonable their positions, if the opponent invokes the rule. However, if a party never invokes Rule 26, instead pleading a request for attorney fees under ARS 25-324 or other applicable statutes, then the safe harbor opportunity would never materialize. In the surpassing majority of Title 25 cases, that is exactly what happens. A party reserves the right to request fees under ARS 25-324, ARS 25-809G in their responsive pleading and never mentions Rule 26. Rule 26 demands are comparatively rare, as they should be given the narrow scope of the rule, and the court has never interpreted that rule as a necessary or exclusive mechanism for seeking fees in Title 25 cases. If the court adopts this interpretation, then the phrase Rule 26 will become the family law equivalent of Beetlejuice or Voldemort or knee. For example, words with magical and counterintuitive effects triggered by their mere utterance. Invoking Rule 26 would have so little value and so much risk that aggrieved parties would never use it again. Arizona law has long disfavored magic words and exalting form over function, particularly when prioritizing formality would undercut the court's jurisdiction in a family law matter. Duckstein v. Wolf, 230 Arizona 227, 232-33, 1016, interpreting Rule 31, former version of Rule 26, verification requirement as merely procedural, not jurisdictional, when a party violated the rule in a custody case. See also ARFL P31, former Rule 31, relating to signing of pleadings, was abrogated August 30th, 2018, effective January 1st, 2019. See now ARFL P26. Historical note, ARFL P24D, pleadings must be construed to do substantial justice. ARFL P86, harmless error stands in Title 25 cases. Duckstein's importance is twofold in this case. One, it is the only known published case interpreting Rule 26, albeit addressing the verification requirement since moved to another rule. And two, it interpreted the verification requirement as procedural rather than jurisdictional. In other family law contexts, error in preliminary procedures must be addressed prior to a resolution on the merits. Sundstrom v. Flatt, 244 Arizona 136, 138, 7-8. In re Marriage of Dorman, 198 Arizona 298, 303, 12. Appellant will have great difficulty showing prejudice from an error in the preliminary verification or screening procedures under Rule 25-411 after hearing has occurred. Granted, Laura's position demands strict compliance with Rule 26, not ARS 25-411, but the family divisions have historically conducted their business informally with greater interest in just outcomes than formality for formality's sake. Laura had noticed an opportunity to be heard, but she wanted notice and an opportunity to unconditionally withdraw after she initiated the litigation and publicly alleged paternity. Clayton testified that Laura contacted his family, acquaintances, employers, national media, and tabloids like The Sun, calling him a deadbeat. The trial court has broad discretion to deny a motion to withdraw a pleading and must award reasonable costs and attorney fees if it determines a party filed a petition not grounded in fact. Sundstrom v. Flatt, 244 Arizona 136, 137, finding no error in trial court's refusal to dismiss upon petitioner's motion to withdraw pleading under ARFL P46. Grow v. Grow, 1 CA-CV-16-0625 FC, 2018 WL 283148. Footnote 6. Cited for persuasive value under Arizona Rule Supreme Court 111C1C because no other opinion adequately addressed an award of sanctions under ARFLP 26, previously ARFLP 31, after petitioner attempted to withdraw their pleading. A publicly available copy of the decision may be found here. In Grow, father petitioned to enforce and clarify a child support order. Mother moved to dismiss the petition and requested sanctions. Father responded and subsequently, quote, filed a motion to withdraw his petition with prejudice, stating he did not wish to proceed with this petition, end quote. The court granted mother's motion to dismiss without awarding sanctions. Mother argued that ARFLP 31, now ARFLP 26, ARCP 11, and ARS 25-324 required the court to sanction father. The Court of Appeals agreed. Citing both ARS 25-324 and ARFLP 31, the appellate court modified the trial court's order to impose a sanction against father. 8. The decision makes no indication that father received a safe harbor notice, but the court still awarded sanctions. Admittedly, Grow v. Grow is not binding precedent and is not procedurally identical to this case, but the appellate court's insistence that Grow be sanctioned, despite trying to withdraw his petition, illuminates the starkly different legal environment in family law cases since separation from the civil rules in 2006. The court was certainly aware of the concept of safe harbor when it decided Grow in 2018, and the idea that a party has an unequivocal right to withdraw their pleading without consequences is nowhere to be found in that decision. D. Rule 11 case law does not foreclose the court's ability to sanction on its own motion. Even if the trial court had sanctioned Laura only through Rule 26, a counterfactual hypothetical, is still would not have erred. Laura relies primarily on Federal Rule 11 case law. Footnote 7. Laura cites Westerkamp v. Mueller, but provides no foundation for citing an unpublished order from the Federal District Court. Regardless, Westerkamp merely applies the holdings in other cases, Barber and Holgate, the limitations of which are explained herein. Laura also cites Arizona Supreme Court Rule 111C-1C in support of Gallagher v. Serrano Law Office's PC, but Supreme Court Rule 111 applies to decisions and orders from the Arizona Supreme Court and Arizona Court of Appeals. Appellee is unaware of any authority permitting citation to trial court orders. Like Westerkamp, Gallagher merely summarizes other cases. It is true that Arizona's civil rules are modeled on the Federal Rules of Civil Procedure, FRCP, and the family law rules were modeled on the state civil rules, but there are numerous important differences in the present language. Accordingly, the ARCPs only apply when expressly incorporated into the family law rules, and case law interpreting the civil rules applies only when the language of the rule is substantially the same. ARFLP 1C. In making this argument, Laura completely ignores the material differences in the language and argues the rules are all functionally equal. In fact, the federal civil rules procedural requirements are much more stringent than the state civil rule, and the family law rule is even more permissive. Turning to the question of whether the court may sanction a party on its own motion under Rule 26, Laura relies on the 1993 Advisory Committee notes to FRCP 11. She admits that the court can sanction a party on its own, but she asserts that requires a show cause order issued before voluntary dismissal or agreement to settle. This is where the difference in language between the federal and state rules are most critical. Federal Rule 11 expressly requires a show cause order and does not permit a sua sponte award without one. See FRCP 11C3 and C5B. Court must issue show cause order and cannot impose a monetary sanction unless it issued the show cause order before voluntary dismissal or settlement. Arizona's Rule 11 does away with this requirement, instead stating that the court must simply take into account the opportunities provided to the offender to withdraw or correct the violation. ARCP 11C1. There is no show cause requirement at all. Family Law Rule 26 dilutes the requirements even further, eliminating both the show cause requirement and the sentence requiring the court to account for the party's opportunity to withdraw or correct the violation. Compare ARFLP 26C1 with ARCP 11C1. See also Himlewski v. Maricopa County, 192 Arizona 1-4-14. Trial court has inherent power to sanction bad faith conduct during litigation independent of Rule 11. To suggest that sua sponte sanctions under Rule 26 require a show cause order like Federal Rule 11 ignores the difference in the rule text entirely. More importantly, Laura received ample notice that the court was considering sanctioning her and a full evidentiary hearing to explain her position. If anything, Laura received more process than even the federal rule requires for a sua sponte sanction. As to whether the court can sanction under other authority after finding noncompliance with Rule 11, the case law is similarly unavailing. In Holgate v. Baldwin, for example, the court said it could not sanction using its inherent or statutory power because that would require a finding of bad faith that was not made below, not because it lacked authority. The district court expressly found the offending party did not act in bad faith, so the infirmity was not with its ability to sanction under other law, but that the required elements were not met in the case before it. Therefore, the district court did not err when it found that Levinson failed to show that Community Bank acted in bad faith to multiply this litigation. To suggest that the court lacked authority to sanction under other law when it simply found no factual basis to do so is patently misleading. The Barber case has the same outcome. The trial court expressly declined to make a bad faith finding necessary to sanction under other authority because of insufficient evidence, not because it lacked the power to sanction. Barber v. Miller accord with district court ruling that party acted ignorantly or negligently, but not recklessly or in bad faith. Barber also discusses the show cause requirement and whether a sanction can be made payable to a party if imposed sua sponte, but it does so in the context of FRCP 11's express provisions controlling these questions. Interpreting FRCP 11, amend to require show cause order and limiting penalty to payment to court. In the instant case, the trial court did make the findings necessary to award attorney fees under statute, so the assertion that these cases categorically prohibit the court from sanctioning under other authorities after Rule 26 was invoked is just not an accurate reading. Laura's arguments from Radcliffe arise from the same incorrect premise that the federal, state, civil, and family rules are substantively identical. Radcliffe says the service requirement in FRCP 11 is mandatory to trigger the safe harbor period. Radcliffe versus Rainbow Construction Company. But Rule 26 requires neither service nor a copy of the motion. Compare. FRCP 11C2, copy of motion for sanctions must be served under FRCP 5 at least 21 days before filing the motion, with ARCP 11C2B, written notice of offending conduct must be served 10 days before filing motion for sanctions, and ARFLP 26C2B, movant must provide written notice of the offending conduct 10 days before filing motion for sanctions. To support her assertion that ARFLP 26 and FRCP 11 have identical requirements, Laura even goes as far as to replace the terminology used in that opinion where the different requirements of the rules are not helpful to her. Compare Radcliffe at 789 with OB 1114-2024-28, replacing strict requirement that a motion be served with strict requirement that a written notice must be served. Plus, even if the court had sanctioned Laura under Rule 26, and even if Laura was entitled to written notice of the offending conduct 10 days before the motion, she received both on December 12, 2023, more than 10 days before her motion to dismiss, and in Clayton's initial response. Non-exhaustive list of alleged Rule 26 violations in Clayton's motion to amend. The state rules also make no distinction, despite Laura's arguments otherwise, between the remedies available for sanctions imposed by motion versus those imposed by the court on its own initiative. Next, to the extent Laura argues more good faith consultation was required, she once again ignores the case history and the language of the rule itself. See ARFLP 9C2A through B. Parties not required to personally meet or contact each other if there is a current order prohibiting contact and the alleged victim is self-represented. Laura had an order of protection against Clayton. She was self-represented in this case at the time of the notice, and the motion for sanctions still attached a certificate explaining the efforts to resolve the offending conduct up to that point. Moreover, good faith consultation is a procedural requirement, not a jurisdictional one, and therefore may not be the basis for reversal after final judgment. See in Remarriage of Dorman, discussing limitations on procedural challenges after trial has occurred. Laura's remaining argument is that the purpose of the rules is the same, so their interpretations must be the same. If the Arizona Supreme Court intended to make the federal, state, civil, and family rules perfectly identical, it certainly knew how to do that. This court must begin from the presumption that the drafters of the rules meant to change their terminology, and the words used in the rules meant what they say. See City of Surprise v. Arizona Corporation. Applying expressio unius to find legislature intentionally included and excluded terms in a statute. Even so, Laura did have opportunities to withdraw her petition before and after Clayton's response. She could have withdrawn the petition any time before the response under Rule 46, and even after the court denied her first motion to dismiss, Laura declined to sign an affidavit that she was never pregnant by Clayton in exchange for dismissal with prejudice. In summary, the trial court did not sanction Laura under Rule 26, so there is no issue here for the court to properly consider. Even so, Laura misstates the federal interpretation of Rule 11 and ignores substantial differences in the Arizona rules. She also fails to account for the opportunity she had to avoid the outcome she now challenges. There is simply no error here. 2. Issue 2. Laura has not shown prejudicial error by judicial misconduct. A. Standard of review. The controlling standard for alleged mistakes in family law proceedings is harmless error. Aksamit v. Cron. No cause shall be reversed for technical error in pleadings or proceedings when upon the whole case it shall appear that substantial justice has been done. ARFLP 86. At every stage of the proceeding, the court must disregard all errors and defects that do not affect any party's substantial rights. Generally, the appellate court affirms, quote, absent a clear abuse or legal error and resulting prejudice, end quote. Davis v. Davis. Counsel cannot find any example of Arizona courts applying structural error analysis in a family law case. The structural error doctrine is a creature of constitutional criminal law jurisprudence. A few cases support the use of a fundamental error standard in civil cases, which differs from structural error in that the complainant must still demonstrate prejudice. See Ortega v. State. Insofar as it is applied to civil cases, fundamental error should be used sparingly. Monica v. Arizona Department of Economy. In Title 8 severance proceedings, fundamental error applies only if objection not made at trial court and requires proof of prejudice. Laura cites unpublished cases from Kansas, A.W. v. LMY, and Marriage of DePriest. Footnote 8. Following a Kansas criminal law precedent, State v. Walker, the court will only reverse if the complainant shows judicial misconduct prejudiced their substantial rights. Mere possibility of prejudice is not sufficient to overturn a verdict or judgment. But they too espouse harmless error review that is nearly identical to Arizona's approach. In summary, if a judgment can be sustained by substantial evidence apart from the challenged finding, it must be affirmed. Black v. Black. Affirming judgment despite trial court basing its findings in part on undisclosed interview of children in custody case. CF Maricopa County Juvenile Action. Number JD 561, 131 Arizona 2529. Unlike in Black, record insufficient to consider error harmless after ex parte judicial interview of children in dependency action. B. Laura has not proven judicial misconduct. Laura uses structural error analysis for one obvious reason. It is the only standard that could result in a reversal without demonstrating prejudicial effect. Because she cannot show prejudice, Laura asks this court to announce an extraordinary deviation from the harmless error standard in civil cases. The opening brief alleges the trial judge performed, quote, a secret independent investigation into the facts, which included reviewing and adopting as fact statements posted on social media, end quote. Laura draws this conclusion from the erroneous finding that Dr. Deans testified that Planned Parenthood is not open on Sundays. There is no dispute that Dr. Deans did not make this statement during her testimony, although she discussed other aspects of Planned Parenthood procedures learned during her time as medical director with the organization. For example, that patients must be identified and cannot be seen anonymously. To be clear, Laura's statements and use of fabricated evidence made issue of the location and date of her purported Planned Parenthood visit long before trial. At her deposition on March 1st, she said the visit was July 7th in Mission Viejo, but she later changed the date to July 2nd and the location to Costa Mesa or somewhere else vaguely in Southern California per her April affidavit. This prompted follow-up with Planned Parenthood and was discussed in pretrial disclosure filings. Acknowledged Planned Parenthood had no record of a July 7 or July 2nd visit. Laura's affidavit stating she went to Planned Parenthood while traveling in Southern California on July 2, 2023, referencing false statements to court revealed by Laura's deposition testimony. Ultimately, however, it was Laura's unfulfilled burden to disclose the details of the visit, including the date, location, outcome, and associated records. To explain the fact that none of the locations she previously disclosed had any record of a visit, she testified at trial that she went to Los Angeles Planned Parenthood on July 2, 2023, using a pseudonym. Dr. Deans credibly testified that Planned Parenthood did not permit patients to use pseudonyms. The court made several findings impeaching Laura's statement, including the closed on Sunday conclusion that, although apparently true, was not given in testimony. Laura argues, as she did below, that this assertion must have come from an internet search. She alleges that the trial judge, quote, went online and performed an undisclosed investigation into the facts, and she then tried to conceal that misconduct by falsely attributing the testimony to Dr. Deans, who said no such thing, end quote. Laura provides no support for the contention the trial judge had illicit intent to, quote, conceal misconduct, aside from pure speculation. Logically, had the trial judge intended to conceal anything, there would be no reason to include the closed on Sunday finding at all. It was cumulative impeachment with no impact on the outcome of the case. When Laura moved for change of judge, alleging bias under Rule 6.1, the presiding judge reviewed the record and summarized the harmlessness neatly. Regardless of the source of the wrongly attributed statement about the operating hours, Laura repeatedly lied about the date and location of the visit. Even if the court accepted Laura's trial testimony as true, that she went to Planned Parenthood on July 2, 2023 and obtained an ultrasound, Laura had already admitted to altering that image and to providing Clayton a 7-year-old sonogram video of twins she obtained online months earlier. The UAR discusses innumerable problems in Laura's presentation that have nothing to do with the July 2nd visit, including her tampering with evidence that it was profoundly obvious that counsel for the petitioner was attempting to coach her answers on cross-examination. Therefore, the truth or falsehood of Laura's ever-changing account of the Planned Parenthood visit was cumulative impeachment, not a critical element of the case. It is nowhere evident how this error materially affected the outcome unless the court presumes the entire proceedings were somehow compromised a la structural error. On the contrary, the record is so inundated with Laura's false assertions, many of which she concealed at trial, that the Planned Parenthood Los Angeles is closed on Sundays finding changes nothing at all. This court need not speculate about the reason or source of the finding to determine it was harmless in view of the overall record. C. If the trial court conducted extrinsic investigation, the facts determined were subject to judicial notice and substantively harmless. Assuming arguendo that the trial judge looked up the operating hours of Planned Parenthood in Los Angeles, Laura has not proven prejudice. Arizona's Evidence Rule 201b2 permits the court to take notice of any fact that is not subject to reasonable dispute and can be readily determined from sources whose accuracy cannot reasonably be questioned. The court may take notice on its own at any stage of the proceeding and give a party the opportunity to be heard. Footnote 9. Laura raised her objections to the finding in a notice of change of judge for cause and a motion for new trial, both of which were denied. Laura does not contest that July 2nd, 2023 was a Sunday. OB 1114-2024, 54. As the calendar shows, that day was, in fact, a Sunday. She also does not appear to contest the truth of the conclusion that Planned Parenthood Los Angeles closes on Sundays, although she contends the truth the statement is irrelevant because it was not in evidence. The question then is whether the trial court could ascertain the fact via judicial notice. State v. Rohers illustrates the broad scope of judicial notice in Arizona precedent. Rohers concerned the inevitable discovery of evidence in a suppression hearing. The trial court found a piece of evidence would have been discovered in the defendant's car based on the police department's standard inventory search procedures. The problem was that those standard procedures were not in evidence. On review, the Court of Appeals took judicial notice of the Phoenix Police Department's operations order on the department's website to cure the deficiency in the trial record. The court used the procedural manual and affirmed based on the provisions therein. The Court of Appeals determined Rohers was not prejudiced because, even though the procedures were not in evidence, the trial court correctly interpreted them. Rohers represents a few key points. 1. Judicial notice may be taken of standard operating procedures not otherwise in evidence. 2. Judicial notice may be taken at any stage of the proceeding, including for the first time on appeal. 3. Even in a criminal case where constitutional protections are at their most robust, an argument for fundamental error stating the trial court relied on facts not in evidence must still establish prejudice. And 4. The appellate court can use judicial notice to cure a deficiency in the trial record if the underlying error did not cause prejudice. The facts of the instant case are not so different from Rohers. Even if the trial court searched PPLA's website and misattributed the operating hours to Dr. Deans because of her other testimony about Planned Parenthood's procedures, that information would be just as, quote, capable of accurate and ready determination by resort to sources whose accuracy cannot reasonably be questioned, end quote, as the police procedural order. Moreover, the PPLA finding is nowhere near as central to the dispute as the orders in Rohers, where the police department's policies were outcome determinative of the suppression issue. Next, Laura contends that a business's operating hours are categorically ineligible for judicial notice based on ABA Format Opinion 478. Ignoring that the opinion is not precedental, its footnote 9 and hypothetical number 1 distinguish between essential and background facts, the latter being properly subject to judicial notice from publicly available and reliable sources. See also Roe v. Gibson, discussing boundaries of judicial notice, including approval of web searches for judicially noticeable facts from reputable sources. The restaurant hours hypothetical sets out a scenario in which a plaintiff sues for unpaid overtime hours, and the judge independently researches the restaurant's location because he believes it would only be open during limited hours. ABA Formal Opinion 478, pages 6 through 7. The opinion stipulates that the notice facts are, quote, key to whether the plaintiff could prevail on a claim of unpaid overtime, end quote, and therefore should have been the subject of adversarial inquiry at 7. Resolving an essential element of a claim with ex parte investigation, particularly basing the decision on the restaurant's industrial area location instead of its posted hours is a far cry from what Laura alleges occurred in this case. Again, the challenged finding in the instant case is not critical to the outcome and does not establish an essential element of any claim. Rather, it is just one piece of impeachment material among countless others. Moreover, there is Arizona precedent supporting courts taking judicial notice of information on websites, albeit government websites in these examples. Peterson versus Bennett. Court may take judicial notice of Secretary of State website. Arizona Public Integrity Alliance versus Fontes. Taking judicial notice of deadlines posted on county recorder website in accord with Peterson. D. Harmless error applies even if the trial court independently investigated and did not notify the parties. Even if the trial court investigated without notice to the parties, the standard of review is still harmless error. Black versus Black is extremely instructive here. In Black, the trial judge conducted an off-the-record interview with the parties' children without notice or agreement of the parents. Black versus Black. The court found, based on the undisclosed interview, that both children wanted to live with their father and only visit their mother. On appeal, Mother argued the trial court erred by conducting an interview and that the judge could not be sustained absent the interview finding. Critically, the Supreme Court said, quote, "Although we find no record of an interview and agree that it should only have been conducted pursuant to a stipulation between the parties, we believe that such error was harmless in this instant," end quote. The court acknowledged that the parties should have been notified of the court's actions, but because there was substantial evidence supporting the judgment apart from any consideration of the interview, the judgment must be affirmed. The relevance of this precedent is difficult to overstate. In Black, just as Laura alleges occurred below, the trial judge independently investigated material facts without notice to the parties. The parties only learned about the interview via one finding in the final judgment, and there was no record of the interview for the Supreme Court to review on appeal. Despite these errors, which Laura would argue are structural and require automatic reversal, the Supreme Court affirmed the judgment using harmless error review. See also Hubert versus Carmody, applying Black versus Black and finding error not harmless if nothing in the record supports the judgment. Laura also cites State versus Anderson, stating that this alleged error is one so severe as to create defects in the trial mechanism itself and affect the, quote, entire conduct of the trial from beginning to end, damaging the framework within which the trial proceeds. But she also explains that the error could only have been made after trial because the issue of whether PPLA was open on July 2nd did not arise until Laura's thrice-changed testimony that day. If Laura is correct that the trial judge read her attorney's blog and made the finding based on what she saw there, then there was no defect at trial at all. That is, unless the court believes Laura's vacuous claim that the judge, quote, manifested clear prejudice and or bias early in the proceedings in the form of multiple unexplained adverse rulings, end quote, against her. Quoting Laura's notice of change of judge for cause. And again, the impact of the finding is meaningless within the broader context of the judgment. If there was ever a time for Arizona's highest court to deviate from the harmless error standard in a family court case, it would have had every reason to do so in Black to protect the fundamental liberty interest at stake. Santosky versus Kramer. Parents have fundamental liberty interests in the case, custody, and management of their child. Yet, the Supreme Court declined, and so should this court. E. Invited errors is not reversible on appeal. Perhaps lost in all this discussion is the underlying reason for the error Laura alleges. Even a fundamental and prejudicial error does not win reversal if the complaining party was the source of the error. See State versus Escalante. Party urging the error cannot obtain appellate relief when they are the source. There is no dispute whatsoever that Laura's misrepresentations are the reason this issue arose. The opening brief acknowledges, and the record proves, that Laura gave several different versions of her account of the Planned Parenthood visit before trial. She also admitted to altering the ultrasound image she initially claimed to have obtained at the July 7th visit, July 2nd, at the Mission Viejo, Costa Mesa, Los Angeles location. She claimed to have been using a pseudonym but refused to disclose it. She never disclosed information accurate enough to obtain any original records, resulting in substantial discovery efforts that were entirely wasted. Had Laura been honest, complied with her disclosure obligations, and not changed her testimony yet again at trial, there would be no reason for any of this inquiry. Moreover, Laura alleges one source for the errant finding, comments left on her attorney's blog about the case. Lastly, this is not a case in which hardship to the appellee can be ignored. In structural error criminal cases, the state is obligated to avoid errors and will not be prejudiced by reversal. It will simply conduct a new trial using its vast resources. In civil cases, however, reversal in the face of harmless error would force the appellee back into litigation without good cause. In the instant case, Clayton did not ask the trial court to find PPLAs closed on Sundays. He did not ask the court to conduct an independent investigation, if that occurred. There was no plausible argument that the outcome would have been different but for the challenged finding. Preventing unnecessary retrial is both the essence and purpose of harmless error. The reviewing court should not waste judicial or party resources over an irregularity when substantial justice has been done. Absent a finding that the record could not support the judgment, a finding that is impossible here, this court may simply affirm. 3. Issue 3. The trial court correctly awarded attorney fees under ARS 25-324, 25-415, and 25-809. For Issue 3, Laura argues the court erred by relying on ARS 25-324 and ARS 25-415 as basis for the attorney fee and cost award. Footnote 10. She also relies on the Rule 26 safe harbor argument raised in Issue 1, the response to which will not be repeated here. Clayton's responses in this section concern only the arguments relating to the applicability of ARS 25-324, 25-415, and 25-809. These arguments are frivolous. ARS 25-324. First, Laura argues ARS 25-324 only applies to proceedings under Title 25, Chapters 3 and 4, whereas paternity proceedings arise exclusively from Chapter 6. She cites no authority supporting this limited interpretation, and counsel can find no example of a paternity opinion declining to consider ARS 25-324. Paternity proceedings nearly always involve determining legal decision-making and parenting time, which places them within the ambit of Chapter 4, ARS 25-803C. Any part other than the state may request determination of legal decision-making and parenting time as part of paternity proceeding. Paternity proceedings always require determination of child support, which places them within the ambit of Chapter 3. CARS 25-809A through F, requiring past and future support pursuant to ARS 25-320. Moreover, courts routinely apply ARS 25-324 in published paternity cases. See, for example, in Re McQuillan v. Hufford, Gellin v. Murray, Johnson v. Eldstein. The instant case is no different. Laura petitioned for findings of paternity and determination of legal decision-making, parenting time, and child support. Laura herself requested attorney fees under ARS 25-324 during the proceedings, including by motion and in her pretrial statement. To raise this argument for the first time now, particularly after Laura tried to avail herself of this same remedy, is both nonsensical and impermissible. State versus Gendron. Our adversarial system properly and necessarily precludes injection of new issues on appeal. ARS 25-415. Next, Laura argues the trial court could not use ARS 25-415 as the basis for sanctions because the false claims provision of that statute does not apply in a, quote, simple maternity case that did not result in the birth of a child. Clayton disputes the no false claims assertion for the reasons described herein, but it is also irrelevant because Laura definitely violated a court order compelling disclosure or discovery. Opening brief asserts there was, quote, literally no basis for the court to hold that Laura violated any order compelling discovery, end quote. But the court found Laura repeatedly violated Rule 49 even after being ordered to comply. The opening brief concedes there was also an order compelling disclosure, ROA 87, but asserts that Laura somehow, quote, fully complied with that order by disclosing all required information, end quote. Yet everyone acknowledges her non-compliance. For example, Laura changed her story about the Planned Parenthood Mission Viejo visit on or about July 7th, 2023, numerous times. Even if there were no other examples, for example, Laura admitting she deliberately altered evidence, the court may treat evasive or incomplete disclosure as failure to disclose. ARFLP 65A3, that is exactly what occurred here. Quote, while she failed to provide records of any Planned Parenthood appointment, Clayton presumably sought records from all Mission Viejo Planned Parenthoods, as that is where, up until today, Laura discloses she sought care. This undoubtedly caused Clayton to incur substantial legal fees attempting to locate records that may or may not exist in Los Angeles, but now appear to have never existed in Mission Viejo. Additionally, Laura acknowledged she altered HCG test results, an ultrasound, and sonogram. Laura's assertion that she fully complied with the disclosure order is simply not accurate. The trial court acted fully within the authority given under ARS 25-415. ARS 25-809G and separate motion requirement. Next, she argues the court could not award attorney fees because, quote, no motion was ever filed seeking sanctions under ARS 25-415 or any of the other authorities cited in the trial court's June 17th ruling, end quote. In fact, the parties cited these authorities in filings throughout the matter. See, for example, ROA 9, Clayton's initial response, ROA 73, 7-8, acknowledging both sides seek award and treating Laura's motion to dismiss as a request for attorney fees, ROA 95-14, ROA 120-14. Laura asks this court to declare fees can never be awarded unless a party files a separate motion requesting them. But the statutes do not even require a formal request from a party, let alone a separate motion. She frames the argument this way because a separate motion would be necessary to support her ubiquitous safe harbor interpretation, but there is no such requirement to be found in the statutes. Lastly, Laura concedes that ARS 25-809G applies to this class of proceedings, saying, quote, the correct statute, ARS 25-809G, does permit fees to be awarded where a party has engaged in unreasonable litigation conduct and such conduct necessarily caused the other party to incur fees, costs, end quote. She argues that the court could not give this award, however, because Laura attempted to invoke safe harbor before most of the fees were incurred. In doing so, she imputes limitations on the statute that cannot be found in its text. The court may order a party to pay a reasonable amount to the other party for the costs and expenses of maintaining or defending any paternity proceeding. ARS 25-809G. Nothing in the statute declares those fees must be incurred before a given date or case event, nor does it contain any safe harbor or other provision allowing a party to withdraw from the litigation at their pleasure. Had the legislature intended to include a safe harbor provision, like it did in ARS 12-349, it would have. City of Surprise versus Arizona Corporation, applying expressio unius to find legislature intentionally included and excluded terms in a statute. In a paternity action such as this one, the statute must necessarily account for defending a paternity action that is falsely premised from its inception, even if more fees are incurred toward the end of the proceeding rather than the beginning. Clayton invoked 25-809G in his responsive pleading, ROA 9, and has since maintained the case was groundless. Clayton sought an order from the court determining he did not impregnate Laura. See ARS 25-806D. If other relevant issues are raised in the petition or response, the court shall proceed to resolve all relevant issues in the case pursuant to the rules of procedure applicable to family law cases. Clayton was absolutely within his right to request that relief, and Laura cannot claim surprise or prejudice that she lost control of the proceedings once a responsive pleading was filed. Sundstrom versus Flatt. Finding no error in trial court's refusal to dismiss upon petitioner's motion to withdraw pleading because ARFLP 46 gives court broad discretion. See also State versus Hansen. Whether to grant a motion for dismissal is within the sound discretion of the trial court. Once a party invokes the court's subject matter jurisdiction, the court has discretion to rule in accordance with the evidence presented. Quote, the petitioning party must be prepared for the possibility that the court will not view the evidence favorably to the petitioner, end quote. Sandstrom, at 138, approving award of sole legal decision-making to respondent without requiring counterpetition. Put another way, an action for paternity is also an action against paternity. Whether Laura's positions were unreasonable at the beginning, middle, and or all throughout the case, the court has broad discretion to award fees it deems reasonable. 4. Issue 4. The trial court did not abuse its discretion in awarding fees for unreasonableness and other litigation misconduct after denying Laura's motion to dismiss. A. Standard of review. A discretionary award of attorney fees will be affirmed if there is any reasonable basis for it. Villa Desjardins versus Flagstar Bank. B. The trial court did not abuse its discretion by awarding Clayton attorney fees. The main thrust of this argument is that Laura attempted to dismiss the case before Clayton incurred attorney fees, and therefore any fees incurred after her attempt to dismiss are per se unreasonable. The opening brief states, in pertinent part, had Clayton's counsel simply picked up the phone in mid-December and asked Laura about her intentions, as Family Law Rule 9c required him to do, she would have informed him that she was no longer pregnant and there was nothing further to litigate. Again, at that point, Clayton's fees were literally $0. This argument is particularly misleading, considering the history of this case, both in terms of when fees were incurred and what Laura asserts Clayton should have done. First, both parties had already incurred attorney fees resulting from the alleged pregnancy dispute before December 2023. Clayton consulted with counsel in the early stages of the paternity action and paid associated fees. Although Clayton attempted to represent himself for some of the OOP-IAH proceedings, he ultimately retained counsel for the evidentiary hearing in CV 2023-053952 on November 2, 2023. The court considered the OOP-IAH proceedings as part of the final evidentiary hearing in the paternity action on June 10, 2024. Discussing stipulation of parties for court to review OOP-IAH hearings, Clayton's challenges to the validity of the OOP, and ultimately declining to award fees associated with OOP-IAH proceedings. Clayton incurred more attorney fees and costs leading up to Laura's first motion to dismiss. It is true that most of the attorney fees were incurred after December 2023, Laura's conduct being the primary reason. But flatly asserting the fees were literally $0 when the case was scheduled for administrative dismissal is literally false. Clayton incurred fees in the IAH matter and for legal consultations and costs before December. Laura's assertion that counsel could simply have called and talked to her is similarly anachronistic. Laura hired an attorney, Miss Platter, prior to filing the paternity action. Although she did not formally appear in the case, this attorney was actively communicating with Clayton on Laura's behalf. Another attorney, Mr. Lopez, represented Laura in the OOP-IAH matters through October and November 2023. Clayton's counsel first appeared in the IAH case and directed communications through Mr. Lopez. Clayton's counsel entered appearance in the paternity action on December 12th, but would not have communicated with Laura while she was ostensibly being represented by one of the prior lawyers. By December 22nd, Ms. Linval had appeared on Laura's behalf. On December 29th, Laura hired another attorney, Mr. Keith. After Mr. Keith withdrew on March 12th, Laura hired her current attorney, Mr. Gingras. Throughout this time, Clayton was not in any position to speak to Laura directly, nor she him, because of the OOP-IAH orders. The point of this history is that Laura was nearly always represented by counsel in some capacity. There was never a meaningful time Clayton's attorney could just pick up the phone and talk with her about the case. More importantly, even in December, Laura was still discussing the pregnancy, despite now asserting she knew she miscarried on November 14, 2023. Compare OB 1114-24-11 with ROA 33-773. From Laura's December 8, 2023 article on Medium.com, quote, "I won't be sharing updates regarding the status of my pregnancy with Clayton. I kindly ask not to receive congratulations or engage in discussions about Clayton and my pregnancy." End quote. If Laura truly believed the trial court had a duty to end the case in December 2023, she would have filed a separate action. State versus Mehta. The proper vehicle to challenge the denial of a motion to dismiss is not an appeal, but a petition for a special action. If she was correct, as she argues, this would have avoided the subsequent proceedings. Instead, she deposed Clayton on February 2nd, 2024, and expanded the litigation through her disclosure and discovery antics, bizarre motion practice, and other conduct. See ROA 86, motion to compel lunch. Meanwhile, despite Laura's current claim that she was involuntarily forced to remain in the litigation, Clayton repeatedly offered to dismiss the case and withdraw all claims if Laura admitted she was not pregnant by Clayton and apologized. See ROA 43, 12 through 13, 54 through 59, ROA 54, 13 through 14, ROA 65, 4, ROA 111, 7, 53. Even before filing her motion to dismiss on December 28th, Clayton's counsel provided a similar affidavit Laura could have signed to end the case, ROA 43-59. The affidavit said, quote, "I was never pregnant with Clayton Echard's child or children," end quote, and assented to dismissal with prejudice. Clayton's goal was not to torment Laura or run up attorney fees. He needed confirmation, either in the form of a sworn statement or a court order, that he did not impregnate Laura to undo the damage her allegations had done. Obviously, she did not accept these offers, but she did threaten to sue Clayton for $1.4 million in collateral action unless he agreed to unconditional dismissal in the paternity case that she initiated and cancel her deposition. Lastly, the opening brief asserts the amount of the fees is not reasonable because of the technical and procedural arguments being made, but it does not effectively explain any challenge to the amount of fees awarded beyond referencing the objections made below. OB 1114-2024-68. Therefore, to the extent Laura asks this court to review the substantive application for fees on such grounds as the reasonableness of the hourly rate, the time expended, etc., the opening brief does not articulate those arguments. They must be considered waived. In re Marriage of Pownall. 5. Issue 5. Laura should not be awarded attorney fees on appeal. This argument asserts Laura is entitled to fees on appeal because of Clayton's, quote, other conduct of aggressively litigating this paternity establishment action despite knowing Laura was no longer pregnant, end quote. Laura's argument that Clayton should not have continued litigating after the alleged miscarriage is anachronistic at best because no one other than Laura knew whether she was pregnant or when that pregnancy had ended. By the time of the motion to dismiss in December, only Laura knew about the 2 sacs she passed in September or October, or July 2023, as she later alleged. Only Laura knew about the October 16, 2023 HCG test showing Laura had either miscarried or that a miscarriage was inevitable. On October 18th, Laura filed a request for pre-decree mediation, arguing, quote, Clayton even acts as if the unborn children don't exist despite a preponderance of the evidence, end quote. On October 24th and November 2nd, Laura testified that she had a, quote, high-risk pregnancy, was 100% 24 weeks pregnant, due on February 14th, 2024, and was being actively seen by doctors McCool and Higley, who she saw last Friday. On October 25, 2023, Laura testified in support of the, quote, validity of the sonogram sent to, end quote, Clayton, and that she, quote, believed she was having fraternal twins, one boy and one girl, end quote. She also, quote, frequently stood up and rubbed what appeared to be a swollen abdomen, end quote, while on video during one of these hearings. At one point, she asked if she could show her belly on camera to prove she was pregnant. ROA 43-3, including screenshot and timestamps of hearing recording. In short, although Laura knew all these facts about the alleged miscarriage, she continued to assert she was pregnant in sworn testimony and court filings. Laura did not give any detail until the status conference on February 21st, 2024. Footnote 11. Laura's motion for confidentiality and preliminary protective order filed January 17, 2024, references her miscarriage in the context of information she did not want to disclose, which also included previous relations, previous pregnancies, etc. It is not clear whether her miscarriages was meant to convey she experienced a miscarriage in this case or was referencing a past event. Even in her December 28th motion to dismiss, she asserted she was not now pregnant without any further details. Clayton was appropriately skeptical of the assertion and asked for documentation. For example, if Laura miscarried November 2nd, a reasonable assumption given her testimony that day, the miscarriage would have resulted in the issuance of death certificates to the Department of Vital Records, ARS 36-329. By this time, Clayton was also aware of Laura's past litigation alleging a coerced abortion and intentional infliction of emotional distress against another person. Laura later commanded the court take judicial notice of that action, so its existence became part of the trial record. See ROA 90. Obtaining proof of how the pregnancy ended would certainly help to elucidate whether there was a pregnancy in the first place, and Clayton was entitled to that evidence. When Laura moved to dismiss the action, Clayton had already filed his responsive pleading and made affirmative claims for relief. Clayton objected to the dismissal because his claims, including a determination about whether Laura was ever pregnant by him in the first place, still needed to be adjudicated. The court followed proper procedure when finding voluntary dismissal was not appropriate and maintaining the action to resolve the remaining claims for non-paternity, attorney fees, and sanctions. Under ARFLP 46, the petitioner loses the right to unconditional dismissal after a responsive pleading is filed. Voluntary dismissal after a responsive pleading requires a motion and the court's approval. The court may dismiss a petition after a response is filed, but only on such terms and conditions as the court deems proper, including the resolution of any claims by the responding party. Here, the court determined dismissal was not proper because Clayton's claims needed to be resolved. At that time, Laura's primary argument for dismissal was that the court lost jurisdiction once the pregnancy ended. It did not. Subject matter jurisdiction is established at the time of filing and cannot be ousted by subsequent actions or events. Fry v. Garcia, Resolution Trust Corps v. Faust, State v. Howell. Quote, jurisdiction depends upon the state of affairs existing at the time it is invoked, and once having attached is not lost by subsequent events. End quote. Arizona law favors retention of jurisdiction unless divestiture can be clearly and unambiguously found. Fry at 73, Pritchard v. State. The only divestiture language Clayton's counsel can find in the statutory scheme for paternity actions is in ARS 25-805, effect of death, absence, or insanity of plaintiff. That statute permits the state to assume the petitioner's place in those circumstances, but is silent as to the effect of the death of the unborn fetus or child. Had the legislature intended to abate paternity proceedings automatically in the event of a miscarriage, it certainly could have done so. It is not difficult to imagine scenarios in which continuing the paternity action after miscarriage is necessary and appropriate, such as for insurance claims or establishing the family's standing to sue for wrongful death. Conversely, in cases like this one, the putative father may have need to prove non-paternity even if the pregnancy does not end in live birth. To the extent Laura argues the trial court's jurisdiction automatically abated upon her allegation she was no longer pregnant, this argument must also fail. Attorney fees on appeal. Echard requests an award of attorney fees incurred on appeal pursuant to ARS 25-324 and 25-809G. Owens has maintained unreasonable positions throughout the proceedings. Her appeal, particularly regarding Rule 26 and the fee statutes, does not make colorable claims for interpreting or expanding the law. Instead, her appeal mostly seeks to misdirect this court with incomplete, inaccurate, and sometimes even substituted recitations of the record and precedents. Conclusion. The trial court admirably resolved this difficult matter and wrote a detailed, comprehensive, and legally complete judgment. The appellant has shown no reversible error. Clayton requests this court affirm the trial court's judgment in all respects, deny petitioner's appeal, and award respondent his reasonable attorney fees and costs on appeal under ARS 25-324 and ARS 25-809G upon compliance with ARCAP 21. Marcus Reisinger, attorney for Appellee, Clayton Echard, Woodnick Law.
SchnitzelNinja!